Hi everyone, I'm Kent Reynolds, a solicitor here at the Jonathan Lea Network. Today I'd like to talk a little bit about lease extensions, what you need to know about them, and whether they are something that you can take advantage of. So what is a lease extension and why does it matter? Every flat or maisonette owned under a lease has a time limit. This usually starts at 99 years or 125 years, but as that time runs down, the leasehold interest loses value. The idea is at the end of the lease period, the flat reverts back to the freeholder, who can then grant another lease over that flat. The law does allow an automatic extension of that lease, so it can carry on indefinitely, but a premium price may have to be paid and a procedure has to be followed. So once your lease dips below about 80 years, it becomes more expensive to extend it due to something called marriage value. Under 80 years, many mortgage lenders won't offer mortgages, which makes it very hard to sell because you're most likely only going to be able to sell your flat to a cash buyer who may be an investor and who will drive a very hard bargain on the price. If you let the lease run too much below 80 years, it then becomes very expensive to extend that lease, which can be a big disadvantage. There are actually two ways that you can extend your lease, which is the statutory route and the informal route. So the statutory route is making use of the law which allows every leaseholder to extend their lease, provided it's one of the qualifying leases. And you can force the freeholder's hand, so they have no choice but to grant you the lease extension, unless, of course, there's a problem with your paperwork or it's not a qualifying lease. The informal way is just simply two parties who have freedom of contract, and obviously a leaseholder can approach their freeholder to ask for a lease extension, and there's nothing to stop the parties just doing that voluntarily. What often happens is a leaseholder may be advised to start the statutory process merely so that they do not lose time if the negotiations break down on the informal route, and so that there is at least some pressure on the freeholder to grant that lease extension in a relatively short time period. So under the statutory law, lease extension, there is an act called the Leasehold Reform Act 1993. This gives you the legal right to a 90-year extension at zero ground rent. The terms are fixed by law, so they are fair and protect you. You must have owned the flat for at least 2 years. What that means is that, say you're selling your flat on a short lease, and if for any reason you can't extend before the sale, you may be able to assign your notice that you've given for the statutory lease extension to the buyer, so that the buyer then doesn't have to wait the 2 year period. It's quite a difficult thing to get right, but it is an option for people that can't extend their lease but need to sell their flat. So the pros of the statutory route is that you've got strong legal protections and ground rent is removed, and you can apply to a tribunal if the landlord doesn't cooperate, and if you can't agree on the price for the lease extension, the tribunal can impose their own view on it depending on valuation evidence that gets filed. Are there any cons with the statutory process? Well, yes, it's a more formal process. It takes longer in some respects, and you'll have to pay the landlords reasonable legal and valuation fees. Another disadvantage of the statutory process is that you'll only get 90 years plus the remaining term by law. So if your landlord doesn't want to give you any more than that, that's that's the most that you can force your freeholder to give you. You can extend more than once, and some people do that. They issue multiple lease extensions for another 90 years plus the remaining term. But obviously that can be quite cost inefficient. Whereas with the informal route, the parties are free to agree whatever period they may want to. And so it may be potentially quicker, it's more flexible, and it can be tailored. But one of the problems is that you can't force your landlord to go down this route, and your landlord could simply pull out at any time. So, are there any eligibility criteria for the statutory route? Well, yes. To qualify for a lease extension, you have to have what is called a long lease. So that's a lease that was originally granted for more than 21 years, and you have to have owned the flat for at least 2 years, unless you're taking an assignment of a previous notice by your predecessor owner of the flat. The property must be a flat or a maisonette and not a house, as different rules apply to leasehold houses. How does the statutory process work? So the first step to take probably is to instruct a professional valuer. So this should be somebody with a qualification as a valuer. So an estate agent's opinion is unlikely to be sufficient for this purpose. You then have to prepare a notice which your solicitor can do. It's a special legal notice called a Section 42 notice, which states the price and the terms. The landlord has 2 months to serve what is known as a counter notice, accepting or challenging your offer. So the landlord could simply accept your offer, and you can then proceed with the lease extension that way. But most likely, there'll be an argument over what the price should be. So they will file a counter notice with what they're prepared to grant. If you can't agree between the two of you what the price should be, then the tenant will have to apply to the tribunal for determination of that. Once terms are agreed and a new lease is registered at the land registry, then the lease extension becomes effective. There are two ways to have your lease extension registered at the land registry. You can either vary the original lease to increase the term, so there'll be a separate document called the deed of variation. Sometimes what happens is something called a surrender and regrant, which is effectively having a simultaneous extinguishing of the first lease and replacing with the new extended lease. There are some subtle differences between the two, and which one is the best to go for is something to discuss with your lawyer once instructed. As for costs, you do need to pay the landlord's costs of the lease extension. This means there are legal fees for considering your notice and serving a counter notice uh, and all that goes with it. Plus, there are reasonable surveyor's fees. For a flat with say 85 years left, the cost could be somewhere between 6,000 and 12,000 in total to extend, depending on the ground rent, and because that's one of the factors for the valuation. So, what are the common pitfalls with lease extensions? Well, the biggest one is waiting too long. So, the longer you leave it, especially if you let it go below 80 years, costs rise sharply. And not getting a valuation first might mean that you've overpaid. So, it's normally quite good value, money well spent to get your valuer to give you advice on what the premium should be. Another pitfall is not getting the right legal advice, and that may mean a problem with the notice if it is not compliant. It is quite a technical area of law.